Legal and Privacy Brief for June 12, 2026. Supreme Court unanimously restricts federal criminal venue in document falsification cases, Abuamo v. United States. California advances legislation to ban surveillance pricing practices that use personal data to charge different customers different prices. Washington federal court rules that alleged spam violations alone can establish Article Roman III standing without requiring proof of economic harm. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief June 12, 2026. Next section, Enforcement Actions. Flagstar Bank $31.5 M data breach settlement. Flagstar Bank reached a $31.5 million class action settlement for consumers whose personal information was compromised in 2021 data breaches. The settlement covers affected account holders and provides compensation for privacy violations and data exposure risks. Financial institutions facing similar breach litigation should note the settlement amount represents significant financial exposure for failure to adequately protect customer data. Compliance action. Review data breach response protocols and cybersecurity insurance coverage limits. Settlement amounts in this range indicate increasing liability exposure for customer data protection failures. Source: top class actions. Next section, Litigation Updates. Supreme Court rules on criminal venue in document falsification cases, Abuamo v. United States. The Supreme Court unanimously ruled that federal prosecutors must try defendants for document falsification under 18 U.S.C. Section 1519 only in the district where the falsification occurred, not where the investigation is located. In a decision by Justice Alina Kagan, the court held that Ahmed Abuamo, who created a fake invoice in Seattle, could not be prosecuted in San Francisco, where the FBI investigation was based. The court emphasized that the Constitution's venue protections require prosecution where the crime's essential conduct elements occurred. For Section 1519, the essential conduct is the falsification itself, which is complete once the document is created with the requisite intent, regardless of where the investigation is located or where contemplated effects are felt. Compliance action. Organizations conducting internal investigations should document where potential document falsification occurred for future venue determinations if matters are referred to federal prosecutors. Source: Scotto S. blog. Washington anti-spam law establishes Article Roman III standing without economic harm. U.S. District Court for the Western District of Washington ruled in Liss et al. v. Skechers USA Inc. that plaintiffs alleging violations of Washington's Commercial Electronic Mail Act, SEMA, have Article Roman III standing based on statutory violations alone, without proving economic harm. SEMA prohibits sending commercial emails to Washington residents with false or misleading subject lines. The court held that receiving misleading commercial emails constitutes a concrete injury in fact, because it aligns with harms the Washington legislature sought to prevent, including wasted time and cluttered inboxes. The decision follows TransUnion LLC v. Ramirez and Spokio, Inc. v. Robbins by assessing whether alleged injury has a close relationship to traditionally recognized harms. Notably, plaintiffs did not need to allege they purchased products, relied on the emails, or suffered tangible economic loss. Compliance action. Email marketing programs targeting Washington residents must ensure subject lines accurately reflect email content. Prior defenses based on lack of economic harm or reliance may no longer prevent litigation under SEMA. Source: Inside Class Actions. Supreme Court denies Alabama's request to execute using nitrogen gas. The Supreme Court denied Alabama's request to allow the execution of Jeffrey Lee using nitrogen hypoxia after lower courts found the method likely unconstitutional under the 8th Amendment. 11th Circuit reversed the district court and found substantial risk of serious harm from nitrogen hypoxia, which would cause 1 to 3 minutes of severe air hunger and corresponding emotional distress, anxiety, physiological stress, and physical discomfort. The district court then determined a firing squad would be a safer alternative and prohibited the state from using nitrogen hypoxia. 3 justices, Thomas, Alito, Gorsuch, indicated they would have granted the state's request. Source: Scotto S. blog. Next section, Regulatory Guidance. FCC E-rate program under review for content filtering requirements. FCC Chairman Brendan Carr announced he is examining the E-rate program, which provides approximately $3 billion annually to bring affordable broadband to rural libraries, schools, and communities. Carr framed the review around concerns about student screen time, but the examination may impose content filtering or censorship requirements on schools receiving E-rate funding. This follows Carr's elimination of a separate FCC program that provided free Wi-Fi to rural school kids, which he claimed was censoring conservative viewpoints and content, despite the program's bipartisan support. Compliance action. Educational institutions relying on E-rate funding should monitor FCC rulemaking proceedings for proposed filtering or content restrictions that could affect program eligibility. Source: TechDirt. Senate Defense Bill proposes unified DoD cyber leadership. The Senate Armed Services Committee's fiscal 2027 National Defense Authorization Act would create a new Undersecretary of Defense for Cyber, Information, and Networks that is dual-hatted as the Pentagon's Chief Information Officer and the principal cyber advisor to the Secretary of Defense. The provision, taking effect in 2 years, addresses ongoing tensions between the CIO and the Assistant Secretary of Defense for cyber policy over jurisdictional disputes regarding cyber operations versus cybersecurity responsibilities. The committee narrowly defeated, 1413, an amendment by Sen. Kirsten Gillibrand to create a separate U.S. cyber force as the 7th military branch. Source: The Record. Next section, Privacy Developments. California Bill S.B. 2564 would ban surveillance pricing. California legislation SB 2564 would prohibit surveillance pricing, the practice of offering different customers different prices for identical products based on analysis of personal data including browsing history, physical location, shopping transaction history, demographics, and mouse movements. A 2025 FTC, the Federal Trade Commission, report found that surveillance pricing services draw upon customer data from vendors, service providers, and third-party data brokers to sort customers into groups for targeted pricing. Research has documented discriminatory pricing impacts, including higher prices charged to Asian customers for test prep services. Princeton Review. Higher ride prices for trips ending in non-white neighborhoods, Uber and Lyft, and age-based pricing discrimination. Tinder charging users aged 30-49 more than users aged 18-29. California Attorney General has initiated an investigation of surveillance pricing practices. Compliance action. E-commerce platforms operating in California should audit pricing algorithms for use of personal data that could trigger surveillance pricing prohibitions if SB 2564 becomes law. Document legitimate pricing differentials based on cost, competition, or inventory rather than customer profiling. Source: EFF Deep Links. License plate readers to add Bluetooth device tracking. Surveillance company Leonardo plans to add Bluetooth sensors to automatic license plate readers, Alper, through technology called Signal Trace. The enhanced devices would capture not only vehicle license plates, but also unique identifiers of mobile phones, wearables, and other Bluetooth-enabled devices in passing vehicles, allowing law enforcement to identify specific drivers or passengers. The technology would transform Alper from vehicle tracking devices to person tracking surveillance infrastructure. Alper are already widely deployed across the United States. Compliance action. Organizations with vehicle fleets or company parking lots should inform employees that their Bluetooth devices may be captured by enhanced Alper systems in public spaces and during commutes. Source: Schneier on security. University of Nottingham confirms data breach affecting 455,000 individuals. University of Nottingham confirmed a cyber incident involving significant amount of data affecting current and former students. The Shiny Hunters cybercrime group claimed to have obtained over 40 gigabytes of data including credit card and payment details. Analysis by Have I Been PWNet indicates approximately 455,000 unique email addresses along with names, addresses, phone numbers, ethnicities, disabilities, passport numbers, and information relating to academic enrollments and fee payments. The university notified affected individuals that access data may include contact information, university-related details, financial information, and personal information including national insurance numbers and protected characteristics. The university is conducting a forensic investigation to verify the exact scope of data accessed. Compliance action. Educational institutions should review data minimization practices to limit collection of sensitive personal information to what is strictly necessary for academic and administrative purposes. Verify encryption of payment card data and passport numbers in student information systems. Source: The Record. Next section, Policy changes. Trump administration policies drive academic research disruption and self-censorship. Survey of 280 academic scientists from 131 universities conducted by Arizona State University's SCI-OPS panel found that just over half reported overall funding declines since January 2025, with approximately one-quarter reporting declines in state, local, and university internal funding. More than half reported that international students or postdocs have expressed concerns about deportation. Over 80% reported that graduate students or postdocs on their research teams have increased concerns about future job prospects. Over two-thirds reported increased work-related stress, and almost half reported increased workloads since January 2025. The survey documented self-censorship actions by scientists in response to Trump administration policies affecting funding, visa restrictions, and diversity, equity, and inclusion programs. Source: TechDirt. Next section, Compliance Takeaways. Review email marketing subject lines for Washington semi-compliance. Sketcher's decision establishes that misleading promotional subject lines, such as false urgency about expiring discounts, create Article Roman III standing without requiring proof of economic harm or reliance. Email campaigns targeting Washington residents face increased litigation risk. Audit pricing algorithms for surveillance pricing practices ahead of potential California S.B. 2564 requirements. Document legitimate pricing variations based on costs, competitive positioning, or inventory management rather than personal data profiling. California Attorney General investigation is already active. Document investigation locations for potential document falsification matters. Abuamo establishes that venue for 18 U.S.C. Section 1519 prosecutions lies where the falsification occurred, not where investigations are based or effects are felt. Internal investigation protocols should capture location information for future venue determinations. Prepare for E-rate program changes that may impose content filtering requirements. Educational institutions receiving E-rate funding should monitor FCC rulemaking and assess operational impacts of potential content restriction mandates. Minimize student data collection following University of Nottingham breach, affecting 455,000 individuals with sensitive personal information, including passport numbers, disabilities, and protected characteristics. Review what data is strictly necessary for educational operations and verify encryption of payment card and identity document information. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.